All right, again, thank you so much for gathering around the table. My name is Rose, and I am one of the Senior Education Ombuds with the Office of Education Ombuds. And today our focus is going to be around student discipline rules. The first thing I wanted to start with was a brief review of who we are at the OEO. OEO, or Office of Education Ombuds, is a state agency. It was created by our state legislature about 13 years ago, so we're finally in the teen years. OEO was created in order to work on tackling opportunity gaps for students in our public schools and to help facilitate partnerships and collaboration between families and schools to support students and access for all kids. So it was really a focus on the connection between families and schools and trying to make sure that our public schools can live up to the promise of working for all kids. We do our work in a few ways. We do individual casework, and that's where we get a call or someone contacts us online or by email. It usually is families who call us first. They are the ones who then could give us their permission if they want to, for us to reach out to schools. We also get calls from community professionals or educators. We get calls from folks like yourself who work directly with families and want to be able to brainstorm around what are some options for a team that's working with a student if you're running into difficulties or conflict if it comes up between families and schools. And when we work with individual families, we have had to set some strategic priorities because we are a small team. There are 7 of us and we work statewide. But when we're able to work directly with a family for a while, we can spend a few months being in touch, usually by phone, trying again to problem solve as they work through a process, often around students with disabilities, can be around discipline, issues of bullying or harassment, or other things that get in the way of a student accessing education. That's our casework, and we do that on the day-to-day basis. We also do trainings and outreach, so we're always delighted to get invites to partner with groups to do trainings like this, because there's always a lot to know about how schools work and how they're supposed to work and what the options are for supporting students. And then on top of that, those things change very frequently. So today we're talking about discipline policy, and that's something we know that has been changing almost yearly for the last 5 or so years. We think we're set now with where it's at for now. So we do trainings, and then we participate in policy work groups. Right now, we're participating in a policy work group that you're closely involved in and have been key in pushing forward, is around language access, making sure families can get effective and appropriate translation and interpretation in order to be able to have communication with their child's school when they need it. We also worked on the policy work groups that had the chance to weigh in on the development of the discipline policy changes. So that is OEO in a nutshell, and I'm happy to cover, as we get closer to the end, specifically how you might or when you might reach out to us to see if we can be helpful if issues are coming up. Today, the call was to focus on student discipline. So the topics today are going to look at our state rules and also looking at district policies. It's going to be important sometimes when you're working with families and schools to have as a reference point what the state rules set as the requirements, and then also to know to look sometimes to district policies for more detail. We're going to talk about some areas that we've seen change in specifically. One of those is in classroom exclusions and in-school suspensions. Those are new to the state rules in the sense that they have new definitions. There's some new and clear requirements around notice and communication with families. And so we're going to talk about that to see what families should be able to expect and ask for around communication and collaboration if a student is being removed from the classroom for behavior. We're going to talk about educational services during removals. It's been a few years now that students should be able to expect that they're going to continue to have access to education, even if they get in trouble. So districts have been working on this, that the type of services and educational supports is going to be different depending on how long they're out. But this is for all kids now and for any removal. Re-engagement meetings, these have been around for a few years now. They're required whenever there's a long-term suspension or expulsion. And one of the key things that we'll focus on today is how to think about re-engagement meetings as a way to be sure that there is a conversation on people's minds about how to get a student back into school as soon as possible. We're going to touch briefly on threat assessments. They're not specifically discipline, but they certainly are coming up, and there's a lot of interaction there. Then we're going to talk with each of these about how is it that these general rules that apply to everyone then interact with some of the specific protections for students who have disabilities. So that's going to be our list of topics. I will just invite, if you do have questions coming up already, please don't hesitate to put something in chat. And otherwise, I'm going to dive right into that first one. So as I switch over, again, if there's questions about OEO or how we work with folks, let me know and we can always come back to those near the end of the presentation. All right, I am hearing, oops, sorry, excuse me for that. I'm hearing some sound somewhere, and I apologize. I don't know if there's someone who's not muted. If you want to check to see if your microphone is muted as we're continuing to record right now. Okay. So state rules and district policies. In Washington state, we have what's called sometimes a local control state. Our state definitely sets some rules that apply to every single school district. But our state also holds on to this idea that each school district ought to have some ability to decide for itself how to do things when there's not a reason why everybody has to do it the same way. When our state sets rules, it is generally, with school stuff, our State Office of Superintendent of Public Instruction, OSPI. I think of them essentially as our state level education department. There are some times when our State Board of Ed is given the job of doing rules, like around graduation requirements. But for the most part, when we're thinking about, is there a state rule that applies for all schools on this issue, we're going to look to see if OSPI has developed rules on that. And they were given the job, and they have done rules on student discipline. And those are for all schools, all students in our state public schools. And those rules are all available online. If you are ever wondering, what was that definition of a suspension? What was that definition of a classroom exclusion? If you want to double check and go straight to the source, you can look at our state rules online, and those are known as the WACs, the Washington Administrative Code. And the discipline rules are under WAC 392-400. One of the things that you can find there, again, are the definitions. What is the definition of this disciplinary thing? And you can also find there the required notice that schools should give when they use that type of discipline, and what the process is if a family disagrees and wants to challenge it. I'm going to do something a little tricky here, and I'm going to see if we can go to the discipline website. Pardon me for a moment. I'm going to have to end that. I'm going to open the website. And one of the things you can do, again, if you get questions regularly about student discipline, I would certainly encourage you to figure out a way to bookmark it on your website, on your Internet Explorer. So let me pull this open. I'm going to try this to share this new screen with you. There we go. All right. So you should now be seeing the website for the state rules. It's under the state legislature website. And I have it so that it shows the complete chapter. And that way I can look quickly and I can see that it covers suspensions and expulsions. I can see that it covers classroom exclusions and emergency expulsions, all those different rules right there, right? And it has a key section on definitions near the top. So I can look at that and I can be reminded of what precisely is the definition of a classroom exclusion. This is helpful if you're getting questions around what does this mean? How long can a classroom exclusion last? What are my rights to appeal? And if you're not sure, you certainly can ask at the school, but if you want to check yourself, this is a good website to do it. So I'm going to go back to the PowerPoint, and what we were looking at there is both the state rules and then secondly, district policies and procedures. And the state rules are important because they set a basic foundation, the bottom line, sort of what's that rule, what do all districts need to be doing. But in a couple places in those state rules, it says, districts, you figure out your plan on this. And so in some of the places, it's going to be really important to also remember to look at the district's own policy and procedure on student discipline to figure out what are the specific next steps, what are the specific procedures if, say, a parent disagrees with a removal from the bus. So finding a district level policy and procedure, what you will do is we'll go back to our website. And I'm going to walk through an example. I'm hoping that what you're seeing now again is the website. And we're going to look for a school district policy and procedure on student discipline. And I'm going to look at Kent because that's, I know you're near Kent. And I pull up the district website. And when I'm looking for a district level policy and procedure, I usually start by looking for a tab that says policies. And I often look at the school district one and I don't immediately see it. So I might go back and I might just actually look and search Kent School District Policies. For student discipline, one of the things to know is whatever district you're looking at, most school districts are going to have their student discipline policies in what's called the student series. I'm clicking on policies and I'm looking at the student series. And I might just scroll on down, but I also could do a little control find, student discipline. There we go. We now have the specific student discipline policy and student discipline procedure for this school district. And if we were to open that up, we would be able to find details about their process. If there's a discipline on the bus, for example, or discipline at recess and a parent disagreed, what's the next step? And I'll tell you, and you probably won't be surprised, that in most situations, districts are going to stick to what is a common kind of step-by-step process in a school district when there's a concern or a disagreement. They're almost always going to encourage families to start at the building level, talk with the building principal and the teacher involved, and then if that doesn't resolve it, then to go to the district level, talk with the superintendent or someone in the district office, and if that doesn't resolve it, to go to the district school board. But I do want to encourage you to feel comfortable and know that looking both at the state rules and at the district policy and procedure is important. In most cases, you're going to find that the district policy and procedure says maybe exactly what the state rules say. And that's helpful. It means it's consistent. There's going to be some of the places where each district will have some variation. So there you go. And what about, those are the general school discipline rules. So we looked at those in the WAC 392-400, right? Today we're talking about student discipline for students who have disabilities, and they might have an IEP or a 504 plan. For students with disabilities, it's important to be familiar with those student discipline rules we just looked at, the general rules that apply to all students, and additional protections that apply for kids with disabilities. Here again, we're going to have a place to look that's from our state rules. It's under 392-172A. Again, I think if you get questions about special education, it's a helpful website to just tab. You can take a look at it. It will remind you of definitions or processes. And that's going to be our state rules. And it's going to describe what the discipline procedures and protections are for kids with disabilities if they have an IEP. Those special ed rules apply for kids who have an IEP, or in some cases of discipline, if they should have been suspected of having an IEP and probably should have gotten an evaluation, there's some sections in there to make sure that they move forward with that evaluation pretty quickly if they're in a long-term suspension or expulsion. Here again though, let's keep in mind those state rules, they're critical, but also look to district policy and procedures. And here, that is especially important if you're working with a student who has a Section 504 plan, but does not have an IEP. In the district policy and procedures for those students, you should be able to find details about a process for checking to see if it's going to be a proposed long-term removal, 10 days or more. Are we going to have a meeting to see if that behavior was what we call a manifestation of the child's disability? Were they behaving in this way because that's what their disability is about? And so for Section 504, check your district policy and procedure. You'd start in the same place on the district website, but this time instead of looking in the student series, these policies are often under the instructional series. If you ever have trouble finding these policies, it should be as simple as calling or emailing the district office and they can direct you to them. Or you can also call and check in with us and I can send you a quick note. It sometimes is a bit of an investigation process to find them on a particular district website, but it should be relatively straightforward. So there we have it. State rules on student discipline in general, state rules on special education and additional protections for students with disability when we're talking about discipline. District policies and procedures on student discipline in general, and district policies and procedures on the protections and rights for students with disabilities under Section 504 or with an IEP. Those are some of the resources that we can look to if we have questions about what to expect with a school process around discipline. So here we go into our first specific piece about some of the new discipline rules and policies. School discipline over many years has changed significantly in Washington State. And some of the very big changes that we often talk about are new limits on out-of-school suspensions and out-of-school expulsions, right? It used to be 6, 7, 8 years ago, a student could be expelled with no plan to return, no end date, right? That was a significant change. Every student who is suspended or expelled now should have a date, the last day on which they're going to return. If nothing else changes, we know they're coming back. It's never a one-way door. One of the other big changes that we haven't talked about as much, and this is now in place this year, is that in addition to the changes to those really kind of more severe consequences, the long-term suspensions and expulsions, We now have the state saying, we're going to approach it differently when we get to the very first sign of difficulty with behavior and discipline. We are going to ask schools and require schools to keep track every time a student is removed from class because of a behavior violation. Not only are we going to keep track of that, but we are going to make sure, school, that you communicate to a family every time a student is removed from class because of a behavior violation. This is now covered under the new rule for classroom exclusions. Now, the classroom exclusion is something that a teacher generally decides, right? Teachers have so much responsibility in the classroom. They're teaching, they're engaging kids, they're responding to their needs. They have the responsibility to keep that classroom a safe space and a place for learning. With that responsibility, they have the authority to decide if a student is becoming disruptive and they've tried other things and they continue to be disruptive, the teacher can decide it's time for me to send you out of class. When the teacher decides that, under the state rules now, the teacher must notify the principal. Then it's up to the teacher or the principal. One of them has to notify the parent. Schools should be figuring out who that's going to be ahead of time, not waiting till the day when this happens. But the key for families is that from here going forward, they should hear about it if a student is being removed from class for getting in trouble for behavior. One of the things to be aware of, and one of the questions that you posed, is what parts of these rules are new? What are schools still figuring out and learning about themselves, right? How to do this. This is one of those things. Some schools probably have had the practice for a while of calling parents at the first sign of challenge. But others have not necessarily had a system for calling a parent every time a child was removed from class. So in some schools, this is new. This is a new system, it's a new process, it's a new habit that they're going to have to develop, of making sure that each time a decision is made that a student is so disruptive, I need to remove them from class, that there is a way to follow up and that they know, now I need to call the family. And so there might be times now when a student is being removed from class, but a family hasn't yet gotten the call. The thing to know about here is that you can ask them what's going on. I'd like to hear about this, and remind them that now this is the new way of making sure that there is early and frequent communication between families and schools if kids are getting in trouble. So the key thing, though, is that this is about being removed from class because of behavior. So there are some kids who might leave class to go to the nurse's room if they're not feeling well. That's not because of behavior. So each part of the definition is important. It's removed from class because of behavior violations. And it doesn't count, so there's an exception, right? Let's say the teacher says to a student, I want you to please be quiet, and the student keeps talking, and the teacher says, please come out in the hall with me. Because maybe the teacher wants to talk with the student, let them know the behavior they want to see, but they don't want to call them out again in front of everybody. If the teacher stays with the student and they step out briefly into the hallway and have a conversation and then go back in, that's not a classroom exclusion. The teacher hasn't said, I'm staying in my class and I'm sending you out because of your behavior. So a classroom exclusion is when a student is removed from that class because of behavior. They stay in school, right? So a difference, another kind of discipline that, again, we now have a new definition in our state rules that defines specifically what an in-school suspension is. It's something that schools have been doing for a while. In some ways, it's similar to a classroom exclusion because for both, a student is taken out of class, it's because of behavior, but they stay at school. So what's the difference? So a classroom exclusion is when they are removed from class and they might go back to the next class. In a classroom exclusion, they have to go back by the start of the next day. So let's say you have a student who's given a classroom exclusion just before lunch on a Thursday. The latest that they'll be back in class is Friday morning, so at the beginning of the next day. For an in-school suspension, it can last longer than that day. It could continue up to 10 school days. The other big difference between classroom exclusions and in-school suspensions is who's deciding whether it's necessary. Again, remember a classroom exclusion, the people responsible for that classroom safety and learning space are the teachers. So teachers have that authority to say, you know what, we're at that point where I need to remove you from class. So teachers decide a classroom exclusion. An in-school suspension is often a longer period of time, and it's also generally a decision made by a principal or assistant principal that says, we think removal from class beyond that class period or the day is appropriate, and they can last, again, up to 10 school days. So the student remains at school in a different place than their regular class, and a new key thing that the state rules have said is it's not okay to just have them sit in a hallway by themselves or just sit outside the office. They need to be somewhere where there's going to be an adult staff person who's there to supervise and also to be helpful if the student needs help with homework or classwork. All right. In-school suspensions also, like classroom exclusions, are going to require notice to families. In fact, schools should try to call parents before they say, yep, we're going to have to do an in-school suspension. They should try to call them early to involve them in this conversation of, do we need to do an in-school suspension or not? And when a principal is thinking about doing an in-school suspension, they need to talk to the student, right? This is the student's right to get notice and an opportunity to be heard about what they did and what consequence the principal is thinking about. When a principal calls a student in to talk with them about this and says, look, I heard that you did this. I'm thinking that I'm going to give you an in-school suspension. At that point, the student needs to have an opportunity, if they want to call their parents to join them for that conversation. This is another new requirement in our state rules. In many schools, they will have had many years of having these conversations just with the student. In some cases, again, they may have had a habit and a practice of calling parents to engage in those conversations with the student, but in many, they will have not. This is a new requirement that the school gives the student a chance to call their parents to be involved as early as possible in this. So then we need to have also, after this happens, written notice, and that can be by email. We are at a perfect place because we have a request to pause for questions, and indeed our next slide is going to be to kind of look at this in a specific example. So I'm going to have this slide up here that has our hypothetical, and I am going to just hit a pause here on our recording. Okay, so we've been looking at a what-if scenario. A student with an IEP spends some time in special ed, most of the day in general ed, gets in trouble in one of their classes, and the teacher sends them to the office several times a week. Each time the student goes to the office, he waits until the end of that period and then goes to the next class. Should the student's family get notice? What could the family do if they hear about this? Number one, yes, as you all agreed, the student's family should get notice with each time that there's a removal from class. And what can the family do? They should get noticed because each of those is a classroom exclusion, right? And what could the family do? As we reviewed, so again, the classroom exclusion, students removed from class because of behavior. The teacher must notify the principal, and the teacher or principal must notify the parent. The student goes back to the class the same day, or they start back in class at the beginning of the next day. On this, what to do, check your specific district policy for the grievance procedure or appeal procedure. In general, it's going to start with an informal conference with the principal and the teacher involved. That conference is an opportunity to find out more about what's going on. Is this a specific issue with that class or the setting? Is it a more general concern, something that's coming up for that student? As you suggested, for a student with an IEP, we're familiar with some tools to look more closely at behavior, like a functional behavior assessment. We can look at their accommodations list on the IEP. Is each of the teachers that works with that child comfortable and familiar with those accommodations? Has there been a difficulty with making sure those accommodations are implemented? Is that part of the challenge? So for a student with an IEP who's facing classroom exclusions, we have a couple of set of tools. We have the process for addressing the classroom exclusions like we would for any student. And we also have the set of tools connected with the IEP team to take a closer look, to check to make sure that their accommodations are being implemented and that the teacher feels comfortable with those accommodations and the student too. You can see what's working well in the other classes if issues aren't coming up there. And if needed, the team could look at doing a formal functional behavior assessment to really dig in and try to understand underlying factors. So that's our classroom exclusion situation. The next what if we have is around in-school suspensions. So let me read this out, right? The same student keeps getting in trouble and sent out of the same class. Then they start getting in trouble for being disruptive when they're sitting in the office. So the office sends the student to the resource room for the rest of the day. The student gets in trouble again the next day and has to stay in the resource room for the rest of the week. Our question here that we'll take a little time to grapple with is, what could the family expect to receive from the school in this situation? And what could the family do if they want to make sure the student can keep going to their general ed classes and that these removals won't continue? So I am going to, again, just pause the recording. Okay, so we had a situation where the student continued to be sent out and was removed for more than a day and just was spending time in the resource room. We talked about expecting that the family would get written notice here as if this were an in-school suspension. If they think of it as different because the student's going to a resource room, we still hope and expect that the family would be brought in and the team could talk about this, because if this becomes a pattern, then the student is losing out on their time in general ed, which could start to influence whether indeed they're in that least restrictive environment that the IEP team decided on when they set their placement. All right, we've been talking about notice to families. And when it is an in-school suspension, that notice should be in writing. For classroom exclusions, it was probably going to be a phone call. For an in-school suspension and for any out-of-school suspension or expulsion, families should get written notice. The state rules are specific about what information should be in the written notice. It should include a description of what the student did. What was the behavior? And why was that a violation of school rules? It should also explain how long the suspension will last. When is it going to start? And when is it going to end? And that's true for an in-school suspension or an out-of-school suspension. So for example, a family should not hear, well, we're going to have them spend some time in the in-school suspension room until we see better behavior. That's not a specific end date. We need to have it be a specific end date. All right. The other thing is that those notices should include other steps the school considered or tried first and why they decided to do a suspension. And then importantly, information about the right to a conference. So here is a critical question that comes up for families for whom English is not the primary language and their ability to read English with fluency is limited. The written notice, according to the rules, should be in a language that the student and parents understand. And the critical question that we often hear and that families are confronted with is, does that mean those written notices need to be written in a family's primary language that's something other than English? Or can the written notice be in English and the school says, come in and we'll have an interpreter there to interpret it if you want, if you're not able to read it, right? So in other words, when that form letter gets sent home with the information about your students' specifics in school or out of school suspension, is that letter going to come in English, even if my primary language is Spanish or Arabic or Tigrinya? Or am I going to get a translation into my primary language? We're going to spend a little bit of time going through that question, but one of the things I want to make sure it's very clear and that families know is that even if the district does not have a translated notice in the family's primary language, the district must provide some form of language access. And so in that situation, if a district does not have a translation and is not able to provide one within the time that the parent needs the information, the district then would need to provide access to an interpreter who could give an oral translation or interpretation of the notice. The bottom line is that not providing access is just not an option. The key is, though, that families will probably need to ask. There are going to be times when a district is proactively going to plan ahead and translate their notices. But they probably will not do that in every language, and maybe not every district will have done it yet. In that case, if a family gets a written notice of discipline and it's in English, and the family does not read English, it will probably be key for the family to reach out to the school and ask for a written translation. And if there's not one available in a reasonable amount of time, to ask, at least for now, for an oral interpretation of the notice. So, okay, if we're all solid, there has to be some kind of access. All right, but do families have to settle for the oral interpretation? I mean, that's usually a one-time thing, right? And what if it's at a meeting when a lot of other stuff is happening? You leave the meeting and you did not take detailed notes of what the interpretation was. So you get back home and you're trying to talk to your family about what are our options? Can we appeal? What does appeal mean? Why did they get in trouble? What was the rule? Well, it's all written there, right? Or it should be, but now I can't read it. And now I'm not in the meeting with the interpreter. So what do I do? How can I still have access to this information that still matters to me and explains what my rights are? When should the district proactively and plan to translate? So this is something where, and I know you are key players and participants in the work around language access for our states. And you probably, or maybe have heard that in the world of language access, the US Department of Justice has described 4 factors that an agency, here a school district, should keep in mind when they are developing a language access plan. And these 4 factors help the agency decide when they should prepare written translations of information that they put out to people. The key thing that I think about here is that these 4 factors are really most helpful to school districts when they're planning in advance for what they're going to get translations of so that they have it available when they need it. Those 4 factors include the total number or the proportion or the percent of the people in the district, the families generally, who have a primary language other than English, and their reading or speaking, writing, or understanding of English is limited. That's one. So how many and what percent? And you're looking at specific language groups. So we know we have school districts with families that speak more than 100 different languages. So the question is, for example, often districts will take a look and say, what are the top 5 languages that families speak and read and write in our district other than English? How many of those families do we serve? And then you're going to ask, how often do these families come into contact with our program or service, this information that we're going to decide whether or not to translate? How important is this information? And how important is it to their access to the service or the program or the activity? And what kind of resources do we have as a district, right? So these are questions that I hope districts are thinking about when they are planning in advance and considering, for example, before the school year starts, should we get translations into 5 or 6 or 7 languages of our new notices of disciplinary action? We're probably going to use a form letter that's going to have most of the information in it for suspensions. And so as we develop that form letter, should we get it translated in advance before anybody even asks for it? Because we know we're going to need it if we want to be understood. And if we get it translated, which languages should we go ahead and translate it into in advance? I was trying to think about it. This is not sort of a legal determination. It's just sort of a brainstorming. If I were working in a district and I was trying to think about what to do and where to suggest that we need to get written translations in advance and be ready to do written translations of specific information as it comes up. Well, let's say we're in a district average size and there are more than 100 languages that families speak or read or write. But the 5 most common languages after English are Spanish, Vietnamese, Russian, Chinese, and Amharic. Let's say that every year in the different schools in the district, we know that we give out more than 800 disciplinary notices, and that includes in-school and short-term and long-term suspensions. And in those notices that we've developed, there's a form. It includes information about what the student's in trouble for, so that's specific to a student. But it also includes information about the rights of a family or the student if they disagree. And again, we're an average size district, so we have average resources. And a question here is, should we develop written translations of those disciplinary notices? Should we do them in all those 5 languages? Do we want to know a little bit more about, how many families there are that speak or read each of those? And then what should we plan on in the case so each of those 800 notices is going to have some additional detail that's specific to a student. So what should we plan on in terms of being ready to provide a written translation of that student-specific information, right? So one of the things is, again, a lot of districts are probably going to translate their form letters in advance. The second question that they'll have to look at is, which language will they translate their forms into? And then another question is, as those specific forms are given to each family where there's been a disciplinary decision, will they translate, or how will they translate the information that's specific to the student? And how can the district make this happen within the district's resources? So I want to share one more slide, and then we can pause for a moment and talk through this issue of written translation and try to brainstorm. Well, one of the things that, we don't have a lot of super specific guidance that says this district must translate into these specific languages and have a system for translating the student-specific information for disciplinary notices. But we do know that the information in those notices is important. And remember, it is really helpful and certainly important to get an oral interpretation of it, right? Especially if, let's say, it would just take a week to get a written translation, but we need to know within a day or so what it actually says. So let's get that oral interpretation right away. But what if I want to revisit that information a few days later or a couple weeks later when I'm talking with my family and reconsidering what I want to do about this, right? Or I'm looking back and seeing, what was it that they said that they tried and didn't work? Or what was it that they said my student did? How long is this discipline supposed to last? Those details. I need to know those going forward. So we're thinking about the kind of information that's there, how quickly we need access to that information, and how often we might want to go back and look at it again, right? If we need to go back and be able to review it, and we're not still in that meeting with the interpreter, we might need to have something on hand. And so even though this feels like an area where sometimes there's not a clear answer, a few years ago, the US Department of Education, they wrote a brief in a court case. And it was a court case that a group of families had brought against a school district. And the family said, look, we are families who, I think all the families, maybe most of them, were Spanish-speaking families. They read and wrote, spoke and understood in Spanish primarily, with limited fluency in English. And they were all families who had kids with an IEP. And they were all families who wanted to be actively involved in the IEP process for their kids. And they all struggled to do that because they were not receiving translations of their children's IEPs. So they would receive sometimes an oral interpretation of it, and that's helpful in the moment. But as they went back to review the IEP during the year, or review it as they prepared for the next IEP meeting, they would look at it and not be able to read it because it was in English and they had not gotten a written translation. And the families were asking the court to decide whether the combination of the need to be able to participate in the IEP process and the promise of equal access under our federal anti-discrimination laws meant that the district should provide access to that written document through a written translation of it. And our US Department of Education, this few years back, wrote and said, yeah, we think that's what the law says. Look, we're supposed to think about how important is the information in this document. We all know it's critical. Those IEPs, they are a vital legal document that outlines the rights of a student. Also, it's for an entire year, right? It's not relevant just one day and then the deadline is passed. It's something that goes on all year. It also explains, what the parents can expect. And so the US Department of Education said essentially, hey, look, meaningful access here means you better do a written translation. So that's what they said about an IEP. So when I think about this, I try to think about what kind of information is in this written notice. How quickly do I need it? And how often do I need to look back at it? And am I going to be able to understand the stuff that's critical for me to know in order to take action as a parent? So if we think about that with a discipline notice, we may well end up thinking that yeah, there are a lot of districts in our area. They're going to be able to and want to and go ahead and do translations of the form letter, right, with the information about what's the process to appeal if I don't agree. And then some of them probably are going to need to and want to do a written translation of the student-specific information. As they encounter languages that are less common, that might be something that they have not planned to translate in advance, but they'll still need to be thinking about and working with families on how to make that information accessible in the moment that it becomes needed. And that is a pretty quick time frame, right? Because an in-school suspension could end within a day. We need timely information. So let's take a pause here in just a minute. Let's talk about language access, because these are some ideas about what we want to be able to see and work with districts to get, but we might not be there yet. We might not be seeing it day to day. What are some options, again, to work with the school, to work with the district, to get into place a process that makes this as effective and efficient as possible, and then opportunity to make sure that, hey, whatever the situation is, remember, not giving any access, that's just not an option. So we got to figure out how to make it work. So I am going to pause for questions here just before we go back. Okay, so we've resumed recording and we've shared that there has been U.S. Department of Ed weighing in and talking about how important it is to have access to an IEP throughout the year. So they've said, look, you really should translate that. When we're talking about disciplinary notices, again, really important information. It's also information we want quickly. So does that mean a translation, an oral interpretation, or both? The key thing is, I really hope families will not be shy about asking and saying, I do need access. Let's make sure that we can communicate clearly about what this is. And if there's a group of families that needs access, then that can help going to the district and talking about that and planning how to use effectively the resources to do some in advance translating and have a system in place to get quick interpretation when there's information that needs to be shared quickly. Okay, back to the regularly scheduled program. Recess, we often get asked about recess. I'm sure you do as well. One of the key things is that a classroom exclusion, according to the state rules, does not include exclusion from recess. So all this that we've talked about with the new rules around notice to families and tracking that and all those kind of things, recess is not part of that because it's an exclusion from the classroom instruction, not from recess. That doesn't mean that anything goes at recess or that families shouldn't hear or that schools shouldn't communicate. In fact, each district should have something in their policy that says, this is how we're going to handle discipline around recess and transportation and things like that. The other thing is that I'm sure you all know better than I, access to physical activity, opportunity to unwind a little is just really key for learning. And so often if we resort to cutting kids' recess and restricting their activity, as a consequence, we set ourselves up for more trouble than what we already started. So if you are working with a child or a family whose child is regularly being excluded from recess, maybe they're struggling with appropriate behavior in an unstructured time, and maybe they do need to have some boundaries around that. Okay, if so, how do we still make sure they get access to physical activity? All right, educational services during suspension and expulsion. This is something that is, again, it's been a few years in place now. The key thing, especially for kids with disabilities and an IEP, I think families have become familiar with the idea that if their kid is removed for more than 10 days, they should still get some kind of educational services, right? They need interim alternative educational services. Now, because all kids should be getting those access to educational services, whether they have an IEP, a 504, or again, no disability, any removal from school, and especially those long-term removals, should include a plan around how they're going to continue to get access to services. The key thing is, let's not wait 10 days to start thinking about that. There's no free 10 days with no access to services. Now, if it's 1 to 5 days, we're going to be looking at getting homework sent home. If it's 6 to 10 days, then we should be seeing someone from the school reach out to the family to say, how are we going to make sure they get to keep up with their work? If it's more than 10 days, this is the key thing, it's always been the case, for a kid with an IEP, it's the IEP team that develops the plan for those interim alternative educational services. And those services need to help the student continue to make progress on their IEP goals and access the general ed curriculum. I'm going to emphasize this because a lot of times we hear if a student is given a long-term suspension or an expulsion and they have an IEP, then they might hear, okay, that means 2 hours of tutoring twice a week. That's what we give. And that's the standard, or something else. Well, the thing is, again, remember, this is a kid with an IEP, an individualized education plan. So while that might be a good starting point, it's still important that the team think about whether that's going to be sufficient and appropriate for this student to continue to access education. Is it going to be enough so that they continue to get a chance to make progress on their IEP goals and access the gen ed curriculum? On that piece, sometimes we hear, we're going to do tutoring to cover all of your areas of SDI, or specially designed instruction, but they leave out the general ed classes that a student might be in. The rules say it needs to include both. So especially, remember that high school kid we talked about with just 2 hours a day in special ed and the rest of the day in gen ed classes, if that kid ended out for more than 10 days, we better make sure that their tutoring or services or whatever that was, both looked at their goal areas on the IEP and looked at how they're going to keep up with their gen ed classes. So it's both. Now, if there's a student out for more than 10 days, they have an IEP or a 504 plan, then we're talking about the manifestation determination process. A meeting with the school, the parents, and relevant members of the team to talk about whether this behavior was directly related to the disability or was a result of failure to implement the IEP. And then if they say yes, then you're looking at going back to school, you're looking at doing a functional behavior assessment, developing a behavior plan, or reviewing one that's already there. If the team says no, not a manifestation, the student's gonna be out for more than 10 days, then the IEP team is talking about how do we make sure that they keep up while they're out? What kind of services is that gonna involve? Again, to work on the goals and access to gen ed. Now, I apologize because you might want to go into manifestation determinations, but today is really going to focus on the general discipline rules and how they interact. There's a lot of good information out there about manifestation determinations. There's some information on OSPI's website, and again, it probably would be included within any district policy, and we could talk about that another time if you wanted. But right now, I want to highlight the other part of this slide, which says, and a re-engagement meeting and planning process. So re-engagement meetings and planning processes began for all students a few years ago, but it's something I think, again, where still the practices are in development. So remember, if you've got a student with an IEP out for more than 10 days, we're going to look at a plan for them to keep up and get appropriate services. If they're out for more than 10 school days, then they also are covered by the state's requirements for re-engagement planning. If a student is out for more than 10 school days, then the school is going to need to work with the family on a re-engagement plan. This I think of as a way to hit pause and check. If you've had a student who's been out, what the rules say now is for 20 calendar days, hey, we better get together and meet. Why are they still out? Could they go back earlier? What else do we need to think about as they get ready to go back? Re-engagement planning should start soon. It can start right away after the removal, but not later than 20 days of the removal or within 5 days before they go back. So let's say there was a suspension of 15 days, then you have to meet at least 5 days before the student returns. So that's going to be less than 20 days. But let's say a student is given a 45-day suspension. And we can remember that for kids with an IEP, even if the behavior was a manifestation of their disability, if it met one of the specific special circumstances, it's for grave bodily harm, weapon, I think drugs. If one of those was present, the school district can remove them for up to 45 school days. If that is the case, then this re-engagement planning is a really important moment to say, whoa, it's been 20 days, they've been out of school. Some things have changed, some things have happened. Now we need to start talking about whether they've learned what we want them to learn, whether any safety concerns are or can be addressed if they were to return early, and what we'll need to do to make that return successful. So again, re-engagement planning, I really encourage you to think about it for kids with an IEP. Anyone out more than 10 school days, if you've gotten to 20 days on the calendar, start the conversation, because what the rules say is those meetings should happen within 20 calendar days or as soon as possible if the family or student asks for it. Re-engagement planning is one of several routes back to school and class if there's been a long-term suspension or expulsion. A school could shorten a removal on its own. They could say, you know what, we reconsidered, we looked into it, we don't need to keep them out that long. A family could, or a student could appeal a suspension or expulsion, and a hearing officer could say, you know what, doesn't need to be out that long. You could get together for a manifestation determination, say, yeah, this was a manifestation of the disability, let's bring them back, let's do the behavior assessment, let's figure out what we need to do to prevent this happening again. If none of that brings the student back and you've been out 20 days, then re-engagement planning. All right, what happened? What kind of safety concerns do we have? What are they going to need to be successful when they go back? And by the way, can we come up with a plan for them to go back early? We don't necessarily need to stick to 45 days. We could shorten that if we believe that the lessons have been learned and it's safe for them to go back. And then a petition for readmission. This is another process where a student at any time can say, look, here was the situation, here's what I've done, I'd like you to consider having me come back early. And then if none of that works, every single suspension and expulsion needs to have a specific ending date. There is a small exception for an expulsion that a school district can petition to extend it, but still they would need to have a specific end date so that there's going to be multiple routes to get back to class. And the idea is that schools and families are thinking about these for every student. Why do they need to be out? What lesson are we hoping they'll learn? What kind of safety issues are we thinking about that we need to be ready for when they return? And is it okay? Can we get them back in now with some supports? Those are the questions that I hope teams are thinking about and asking periodically as a student has been out of school. You're not waiting until the end date to start that conversation. Well, so then more and more frequently, we're seeing an additional element. And this is not a disciplinary thing. And school districts, I think, will insist and say threat assessment is very distinct from school discipline. A threat assessment itself is not discipline. A threat assessment by itself is not a reason to expel. It would be the behavior that prompted a threat assessment that might lead to a suspension or an emergency expulsion if they think there's an imminent threat. But we are seeing school districts develop threat assessment programs. In fact, our state law now requires school districts to have threat assessment programs. We are going to see a state model policy and procedure on threat assessment come out in January, just 1 month from now. And in that, school district threat assessment programs are supposed to be focused on behavior. focused on a specific behavior, not a general concern about a student, focused on behavior that's considered threatening or potentially threatening. And for a student with disabilities, we are supposed to see coordination with a student's IEP team or 504 team. And we know that includes families. And that the recommendations, supports, changes to the student's placement, those should all be consistent with the IEP and the IEP process. As this comes up more and more, families may need to be assertive in asking for information. They may need to be assertive in saying that they want to be a part of the process of deciding what will happen and understanding the information that the school is looking at in making those decisions. So threat assessments are potentially going to come up. And again, we will see state model policies come out soon. If, let's say, a student's been getting in trouble, they're getting sent home early, short-term suspensions, then they get an emergency expulsion for making threatening statements. The student wants to have a threat assessment done with an outside evaluator before the student returns, but the earliest appointment is in 20 days. What kind of meetings are we going to expect to see in this situation? Will the IEP team need to meet? And what will the IEP team need to decide? How does this emergency expulsion play out together with the threat assessment? So I know we're running really close on time, but I am going to pause, resuming recording. So here we've got the threat assessment coming up with disciplinary action. An emergency expulsion is no more than 10 school days. And so the school district is going to have to make a decision before the emergency expulsion ends of whether there's a basis for a long-term suspension. And again, long-term suspensions, there are some specific categories of behavior that can justify a long-term suspension. They also, with a student with an IEP, will need to be consistent and follow the process for manifestation determination meetings, at which point, if it is a manifestation, then the student returns to school unless there's an agreement otherwise. So these are things to keep an eye on. We've covered a lot of specific information, and there's specific rules, there's new definitions, there's notice here within a certain amount of time with certain information in it. But what's the takeaway? Because we can't memorize all of that. I hope, if nothing else, the takeaway for today is that every time there's discipline, we want to think about notice. What am I getting in trouble for? What is my kid getting in trouble for? And then opportunity to talk it out. Does that make sense? Why so long of a removal, for example? So the key for families, we want notice. We want to know why a kid is getting in trouble and that they are. And we also want to have a chance to talk about it. So whether it is a call home or a student being able to call mom or dad, whether it's a classroom exclusion, an in-school suspension, or a short-term suspension, if a family's not heard, I hope they won't be shy in following up to say, I want to know specifics. What was going on? And why did you decide on this discipline? And then can we have a chance to talk about it? If this is part of a pattern, let's get ahead of it. The other takeaway is educational services. It's now clear in our state, if a student messes up and misbehaves, that does not mean we stop educating. In fact, a lot of times it's going to mean we have to think about what other skills are we going to work with them on, right? So the key is, for any removal, think about how the student keeps up, right? Discipline should not cut off education. For students with an IEP, don't be shy about saying, hey, I'm part of an IEP team and I'm part of the team that decides what this looks like for this kid. It is individualized. We may have a starting point, but we have to check and make sure that these services during this expulsion or suspension make sense for my kid. And then lastly, every single child returned from school has a plan to get back. And it might be the last date on a suspension notice, but in many cases, it could happen before that. So be thinking when a student is removed, how do we keep them up right now, keep them going right now? But hey, if they've been out for 10 days and they have an IEP, are we looking at manifestation determinations? What's that? Are we meeting? Let's talk. If they've been out for 20 days, ask to start the re-engagement conversation. When could they get back into school? What did we want them to have learned? What kind of safety concerns do we have? Have we addressed that? Do we have a plan for it? And could we start talking about an early return? Every child should have a return date, and that is the last possible date, not the first date that they might be returning. So be ready to have these conversations. And again, I think as you've pointed out, it's not necessarily going to happen automatically. Families might not feel comfortable seeming like they're second guessing a district, a school principal. School principals might have had a practice around this, right? They're adjusting too. The ideal is that they become partners and collaborators in figuring out how to help make sure students have the support they need to meet the behavior expectations so they can keep school a safe place for all kids, a place where they're all able to learn. And if kids need to be removed, that it's not for any longer than they really need to be out. Because it's harder to provide an education when you're not in school. If you can get them back safely, get them back with a plan, that's the ideal scenario. And there's different routes to do that. Here's how you can stay in touch with us. I've taken up all of your time and a little bit more. So I'm going to go ahead now and stop the recording and take any last questions or feedback, and we will wrap up. Thank you so much.